Good evening and welcome to the Kansas City Public Library. I'm Henry Fortunato, Director of Public Affairs. So, in our continuing efforts to bring you lectures on topics that are non-controversial and likely to provoke a mass outbreak of narcolepsy, we're pleased to present the fourth in our series of legal landmarks programs, which tonight focuses on the Supreme Court's 1973 Roe v. Wade decision. This series, I should add, is co-presented by the Truman Library Institute and the Federal Court Historical Society. It is made possible by grants from the Ewing Marion Kauffman Foundation Legacy Fund. Additional support has been provided by the law firm of Spencer, Fane, Britt & Brown, and the Legal Landmarks series is co-sponsored by the University Press of Kansas and the University of Kansas School of Law. As is traditional in this series, the formal introduction of tonight's speaker, Peter Charles Hoffer, Distinguished Research Professor of History at the University of Georgia, will be made by someone who himself is a noted legal scholar. That would be Stephen McAllister, former Dean of the University of Kansas Law School and now the E.S. and Tom W. Hampton Distinguished Professor of Law at KU. Stephen, I should add, knows his way around the Supreme Court. To be sure, he's a nationally respected constitutional law scholar. He's a two-time Supreme Court law clerk, first with Justice Byron White and then with Justice Clarence Thomas. Additionally, besides his law school duties, he serves as the Solicitor General of Kansas and has argued several cases before the Supreme Court, most recently in 2011. Before I turn the podium over to, I just like the sound of this, Barrister McAllister, I do have two brief announcements. One is in the form of an advisory. The other, shall we say, is a rather strongly worded request. First, the advisory. Dr. Hoffer's talk is based in part on his book, Roe v. Wade, The Abortion Rights Controversy in American History, which was published by the University Press of Kansas. It will be available for sale following tonight's presentation, courtesy of our friends at the KU bookstores. This will take place in the cafe behind me, and Dr. Hoffer will be signing copies that you might want to purchase. And now for the request. We present these talks because we believe that your library should be a center for public dialogue and civic engagement. But at all times, we hope and indeed expect that the dialogue and the engagement will remain civil as well. As I've said before on numerous occasions, particularly when we've had talks on plain vanilla topics, like tonight's presentation, this is particularly important during the question and answer session. As the name implies, this is an opportunity for you to ask a question of a highly regarded scholar, something that most of us don't get to do every day. But it's about asking a question, not making a speech, tempting as that might be. And then it's about receiving an answer, not engaging in an ongoing conversation, tempting as that might be. I know you understand, and I know you'll follow these modest little procedures. Ladies and gentlemen, please welcome Stephen McAllister.
Well, it's my pleasure to introduce tonight's speaker. I teach constitutional law at the University of Kansas School of Law, and of course we do cover Roe versus Wade. After we cover it in some detail, I give my students a true-false quiz about Roe versus Wade, and I'm going to give it to you tonight. I probably won't give you the answers, but I'll let you think about them. I asked the students to evaluate several statements, assertions that I make about the case, and decide whether they think they're true or false. First one, there is no basis in the Constitution for finding a right to have an abortion. Second, Roe is about individual rights. Third, Roe created an absolute right to terminate a pregnancy. Fourth, the unborn are persons whom the Constitution also protects. 5, justices vote based on whether they favor or disapprove of abortion. And then one that is particularly fun, it's an either or. So first option, Roe is a great decision, like Marbury versus Madison, Brown versus Board of Education, or Roe is a horrible decision, like Dred Scott or Korematsu. Finally, Roe settled the abortion question in America. I think you can answer that one. Ultimately, it's well worth thinking about what is the lesson or what are the lessons of Roe versus Wade. And I think one lesson may have played out just recently in the same-sex marriage cases, where certainly the court did not go as far as it might have in addressing that topic. And at least some members, like Justice Ginsburg, have repeatedly cautioned that maybe Roe teaches that lesson about the court and its relationship to the people, whether the court gets too far out ahead or not. Roe and the topic it addresses certainly creates strong feelings in people on both sides of the debate. For me, it's particularly refreshing and important to think about the case objectively, and our speaker tonight has been credited with being able to do just that. Peter Charles Hoffer is an accomplished historian at the University of Georgia, the author or co-author of numerous important and fascinating books, not least of which for tonight's talk is his book with a co-author, Roe versus Wade, The Abortion Rights Controversy in American History, published by the University Press of Kansas. Reviewers of the book have praised it as follows. And to me, when you're talking about a case like Roe versus Wade, this is high praise indeed. Studies of abortion issues are common, but mostly partisan. With a deliberately and rather successfully even hand, the authors set out to answer one central question: how did abortion become illegal in America? Another reviewer said, while there are hundreds of books on various aspects of abortion in society, this one does an unusually good job of covering the full legal history from colonial times to 2001. So please join me in welcoming our speaker tonight, Professor Peter Charles Hoffer.
That works. Thanks for coming. That's a serious storm out there. When you come from Athens, Georgia, you look at those storms and you say, please, just be a storm. So please, just be a storm. There's a famous historian about 100 years ago who prefaced a public lecture like this, and he said, never apologize, never explain. In the process of apologizing and explaining for what he was going to say. I'm going to ask for your patience because in the process of writing this for this group, this is the first time that I've given this. You know, there are a lot of pundits who go from place to place, and every whistle stop they give the same talk, and they don't have to look at their notes because they know the talk. I'm going to be reading parts of this, so I ask your forgiveness. Thanks for that wonderful introduction, if I can. There you are. You notice how the professors always sit among you? Okay. And to everyone who sponsored this, the foundations, the funds, the firms, the Kansas City Public Library, the Truman Library Foundation, the Landmark series. I'm sure I've left people out, but I'm honored to be chosen. I should add, however, that the co-author of the book probably would be better at this than I am. N.E.H. Hull is Natalie Hull, to whom I have been married for I better get this right, 43 years. And we've written a number of books together. She's a law professor at Rutgers Camden, so she's one of you guys, and so on. But I'm not sure that I'm the right person to give this. I'm a legal and constitutional historian. I also do historical methods. And when I lecture, when I write, I like to pride myself on my objectivity, which doesn't mean that I believe that you can be objective when you do history. But it's something that we aim at. This is a case which is a landmark case and has become itself a kind of paradox. It was a case that was meant to settle an issue and itself became a target. So I'm going to give you a series of, I don't have any assertions and I certainly don't have an exam for you. But I'm going to share with you a number of sort of propositions. And then from those, I'm going to draw a conclusion. And my first proposition, I'm going to switch to my reading glasses. Trifocals. You can't understand the history of abortion law unless you associate it with birth control and birth control law. Right? At the same time as abortion became illegal, so did birth control. When the efforts to make birth control legal began to bear fruit, so did efforts to reform abortion law. We know that the last remnant of 18th century birth control law prohibiting the dissemination of information on birth control was struck down in Griswold v. Connecticut in 1965 for married couples, and then for unmarried couples in Baird v. Eisenstadt in 1972. How am I doing? Did I get that right? Okay. Looking over there. The ghost of Abe Shays, you know, is sort of watching both of us. Okay. But you cannot find anything about the basis for the protection of birth control in the Constitution. It's not there. Right? So you have to construct it. It may or may not appear in those mysterious, brooding penumbras of the Bill of Rights or in the Ninth Amendment. But these days where we are trying to guard our privacy from various intrusive federal institutions, surely the idea of privacy protected by the Constitution is more important to us, even though it has become more problematic. The Warren Court found it somewhere in the Constitution. And what that suggests to us is that out there with you, not in the law books, not in the courtrooms, but in your evolving sense of what is right and wrong, and what people should be allowed to do and what people should not be allowed to do, that could come into the Constitution. And that's what happened. Justice William Brennan called this a living constitution. Now, I don't know what that means. It's a kind of a vague term, and I've been reading a book by a federal appeals court judge, Harvey Wilkinson, who was a very smart man, and he says that this is dangerous because it's vague, but just about everything in constitutional theory is vague. That's right. Okay. So I think a better source is the Ninth Amendment, and I'm going to read you the Ninth Amendment. You don't have to take notes. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So the question that emerges is, retained where? I looked for the right to privacy in my Lexis Advanced Federal Case database, and I didn't find it. You can't find it in the federal case. It was not in precedent. You cannot find it in the Constitution's text itself, and Justice William Rehnquist, dissenting in Roe, said that he couldn't find it either. Right? So even after Griswold, most states regarded the performance of an abortion as a crime. The abortionist was the putative perpetrator. The pregnant woman was not a co-conspirator, however, nor was she an object of punishment, and this defies logic. All right? If the fetus was in fact an unborn child, and the future mother had procured the abortion, she was a conspirator, if not a principal, in the murder of her unborn offspring. Thus, the existing law before Roe that criminalized the performance of an abortion, to anticipate Justice Sandra Day O'Connor's phrasing in her criticism of Roe, it was at war with itself. In the 1960s, the American Medical Association, the American Bar Association, the academies of this, that, and the other thing, and the drafters of the model penal code saw a way out of this conundrum. Make the therapeutic abortion, you see, you can change it by adding a modifier, the therapeutic abortion, make it legal. An abortion necessary for the health of the mother, doctors would make this decision, not lawyers, not lawmakers, and certainly not prosecutors. Nothing in this, however, found a right to an abortion in the Constitution. That novel argument came when two newly minted University of Texas lawyers, Linda Coffey and Sarah Weddington, who were looking for a client who wished a safe and legal abortion, all right, Roe, a doctor who wished to perform such abortions in a safe environment, and a married couple who feared that another pregnancy would harm the wife's health. Texas law, which is once again the model for state abortion law, at that time made all abortions at any time, even for those pregnancies arising from incest and rape, and those that might lead to serious mental or physical ill for the prospective mother, a felony. Weddington and Coffey argued that the Due Process Clause of the 14th Amendment stopped Texas. And when the case named Roe v. Wade, Wade, you know, was in fact, you've all seen a picture of him. He's the man standing in front of Lee Harvey Oswald when Lee Harvey Oswald is shot. He's the district attorney of Dallas. All right. Case heard by a federal panel, three-judge panel, because they wanted an injunction. It agreed with Coffey and Weddington, but it didn't enjoin Texas. It didn't stop Texas from prosecuting doctors, and Texas kept right on prosecuting doctors. So both sides in that lower federal court appealed. In the meantime, a sleeping giant, evangelicals who had been largely apolitical were awakened, and they joined to existing Roman Catholic efforts against the legalization of abortion, added a powerful counterweight to the rising women's movement that was in favor of reproductive rights. Thus, right to life and pro-choice began their war. It is still with us. When it came to the Supreme Court, the Texas case was joined to a Georgia case. Georgia had a reform statute which allowed certain kinds of therapeutic abortions. The High Court voted 7-2 with Justices Rehnquist and your Justice, Byron White, dissenting. The 14th Amendment did not apply in the case. So they struck down the Texas law and they struck down the Georgia law, but they didn't say what a law should look like. After truly agonizing efforts through two sets of oral arguments to find a way through the thicket, Justice Harry Blackmun came up with a balancing test. It's important to understand that in a balancing test, this would be my answer to one of your questions. How can you ask true-false questions about this? That's what law professors do. They provoke. Okay? It's a balancing test. And what he wrote was this: the state does have an important and legitimate interest in preserving and protecting the health of the pregnant woman, whether she be a resident of the state or a non-resident who seeks medical consultation and treatment there. And it has still another important and legitimate interest in protecting the potentiality of human life. These interests are separate and distinct. And he came up with the trimester formula. You had an absolute right in the first trimester. The state could start regulating in the second trimester. In the third trimester, the state, in the effort to protect the unborn offspring, could even bar an abortion. All right, here's my second proposition. All right, even those who were sympathetic to women's reproductive rights after Roe were not happy with the reasoning of Blackmun's opinion and with the role that the court played in abortion law. Some of these critics argued that Blackmun's reliance on medical evidence and his solicitude for the doctor-patient relationship, because he had been counsel for the Mayo Clinic, was ill-placed in a case that should have rested on constitutional grounds. Others said his due process analysis was wrong-headed, that the case should have rested on the Equal Protection Clause. Some argued that the court had taken on itself a policy-making role, properly allotted to legislatures in our system of checks and balances. Now, courts do this. They say they're not, they're deciding just the case before them, but they often make prospective or policy kinds of law. Other jurists and observers have suggested that the abortion rights advocates were wrong to rush to the federal courts because they were victories for abortion reform in a number of state legislatures, which happened to be on both coasts. In the heartland, it was clear that if you went to the state legislature, you weren't going to win. You weren't going to win. Okay? So, would returning to the text of the Ninth Amendment answer the concerns of these critics? Well, let's return to it, and then we'd have to ask, who are the people referred to in the Ninth Amendment? The rights that the people have. If the right to privacy is the basis for Roe v. Wade, and that right is found in the amendment, then the people are pregnant women. If life begins at conception, does not people apply to the unborn? Press that a little further. If states under Roe have a legitimate interest in the life of the unborn and human life begins at conception, or when a fetal heartbeat can be detected, as the state legislature and the governor of North Dakota have decided, or when ultrasound reveals something that looks like a baby, or when the fetus can feel pain, do states not have the obligation to protect future life and health of the fetus by barring abortion altogether? Enough speculation. Back to history. A decision that was supposed to settle the issue did not quiet the issue. It became, as I said, the target. Meant to permit safe and legal abortions as a constitutional right early in the pregnancy, the decision prompted states and local authorities to find ways to deter or deny abortions. Now, here I'm preaching to the choir. Missouri has a special place in this history. It was not one of the forum states of the cases that were leading up to Roe. All right. But Missouri's legislature and its governor soon expressed a very strong interest in the issue. In Planned Parenthood of Missouri v. Danforth, 1976 case, a St. Louis abortion provider brought suit against the state law requiring parental consent and spousal consent in the first trimester. The statute fell. In Planned Parenthood of Kansas City versus Ashcroft in 1983, the state had passed a law requiring that all second trimester abortions take place in hospitals, along with the understanding that hospitals and physicians in them could refuse to perform the abortions if it violated their religious beliefs. The court struck that down, but allowed a provision that one parent's consent or a judicial bypass be required for a minor to obtain an abortion. In Webster v. Reproductive Health Services in 1989, the time seemed ripe for pro-life advocates to have the court overturn Roe v. Wade. With the addition of Justices Sandford O'Connor and Anthony Kennedy, the old majority for Roe had become a minority. The 1986 Missouri law, a third iteration of previous statutes, including portions that the court had previously struck down, had 20 provisions beginning with a legislative finding that human life began at conception. Parenthetically, legislatures make these kinds of findings all the time. The New York State legislature made a finding that working bakers for more than 8 hours a day was bad for their health and bad for the people who ate their bread. The Supreme Court struck that down. So legislative findings are not always sacred in the Marble Palace. In addition, that all abortions after the 16th week be performed in hospitals, that no public hospital or hospital receiving public funding perform abortions, and there were others. All right, these provisions were some of the same that were struck down in Ashcroft. Lower federal courts, except in Alabama, are required to follow the rulings of the Supreme Court. It is not just the fact that I teach at the University of Georgia that I have these feelings for Alabama, and I hope that anyone here from Alabama will not be offended. We'll lose to them again in the SEC championship. This is some, but state legislatures are not bound by these rulings and can pass legislation that is admonitory, expressive, or simply opinion. Was Missouri then engaging in a species of massive resistance, similar to the stance of some Southern legislatures after Brown v. Board of Education? Or is the proper historical analogy the Northern states' passage of personal liberty laws in response to the Supreme Court decisions protecting slave catchers in Prigg v. Pennsylvania and denying citizenship to all people of color in Dred Scott v. Sandford? In any case, under the new law, doctors were not to advise patients to have abortions, even when it was a medical necessity, but were instead to read a prescripted informed consent. A requirement, again, that the High Court had already struck down in an earlier Ohio case. Finally, the doctor performing the abortion was to perform a series of tests to determine whether the fetus in utero was viable. And this test was, because of the way you had to do it, somewhat dangerous to the fetus itself. So again, you have this irony of a kind of a law that is at war with itself. The stakes, obviously, were very high. The High Court did not reverse Roe, but it found the preamble moot and accepted all of the previously barred regulations save the spousal consent. Attorney General of Missouri, William Webster, I don't know if you know him, an absolutely superb lawyer, had argued that the court, if it agreed with all of the Missouri provisions, should strike down Roe because that's what it was doing. But Justice O'Connor came to the case's rescue. She proposed a compromise, the undue burden test. All right? If a provision placed an undue burden on a woman seeking the abortion, then it would be struck down. Now again, I admit invincible ignorance when it comes to understanding what an undue burden is. I know what burdens are and I know what undue is, but when you put them together and use them as a constitutional test, the fog of war. But it saved Roe. It saved Roe. The right to an abortion was no longer fundamental. But again, a sort of vaguer balance was struck between the interest of the pregnant women in her own reproductive life and the state in the prospective life of an unborn child. Now, instead of settling the issue, Webster, followed by Casey, followed by a series of other cases having to do with various kinds of abortion techniques, proves that the undue burden test simply forces the Supreme Court to hear every statute. So there are all these other cases where judges have issued temporary injunctions that are going to wander up to the steps of the Supreme Court. Historians weighed in for the first time in an organized way in the Webster case. A brief prepared by the University of Oregon historian James Moore, signed on by a number of historians, quite a few actually, and he had written a book called Abortion in America. The historians following that book argued that Roe was rightly decided and based it on the historical fact that abortion was not illegal until after the Civil War, and that was true. When it became illegal, it was hedged around, you can see it in the statutes and the language of the legislative intent, with racialist and misogynistic language. The idea was to protect the ruling race, the next generation of the ruling race, from diminution. All of these people coming in who weren't Anglo-Saxon, from Southern Europe and Eastern Europe and from Asia, and the ruling race must be protected. The brief also noted that in the latter part of the 20th century, the various AMA and the AB and so on had all come to believe that therapeutic abortion should be safe and legal. Michael Grossberg, another leading historian who I greatly respect and formerly editor of the American Historical Review, writing about the belief and public historian, he argued that the brief was right on target. A few months after that article came out, I ran into Jim Moore, we talked. And he said that writing the brief was a nightmare because the lawyers were striking out all of the nuances, all of the things that he said that could have been used by the other side. All right? And this is the problem that historians as expert witnesses and that those of us who sign on to Friends of the Court brief have all the time. One of those nuances is my third proposition. What may be called the Roe conundrum is not without precedent. There are two other cases in which the court proved itself, for better or worse, the most important or the most notorious branch of the federal government. One comes from the other side of the state, and the other comes from just the other side of the boundary between Missouri and Kansas. You can probably guess. I could give them a quiz and see if they can guess what these two cases are. All right, but I won't. There were cases in which the court was either ahead of public opinion or wade into the middle of a furious public controversy. There were cases in which the court made law for the entire country rather than simply resolving a dispute between a finite set of parties. One has been called a self-inflicted wound, the other is generally regarded as the court's brightest moment. In neither case was the right precisely found in the Constitution. Both of the cases were cited in briefs for the court in Roe. They are, now I will reveal them, you didn't give them the answers. Dred Scott v. Sandford from St. Louis, in 1857, Brown versus Board of Education of Topeka in 1954. And their history, I believe, tells us something about why Roe still has the power to divide us. In Dred Scott, Chief Justice Roger Taney, writing for himself and Peter Daniel, the result was subscribed to by 5 other justices, but only Taney and Daniel say the two dicta that made the decision so infamous and ominous. The majority determined that Dred Scott's appeal for freedom based on his sojourn in free states failed. His slavery reattached when voluntarily he returned to Missouri. That was true as well for his wife, Harriet, and for Eliza and Lizzie, his 2 young daughters. Parenthetically, people don't realize this, Sandford was not really interested in Dred Scott. He was a very old slave. His utility was far outweighed by the cost of keeping him alive. His wife was working as a washerwoman in St. Louis, not much value. But the 2 girls, Lizzie and Eliza, they were tremendously valuable, not just for the labor that they could provide, but also they would have children who could be bought and sold on the slave market. Right, and that's why the executor of Captain Emerson pursued the case. As well, because he was still a slave, Dred Scott had no standing to bring the suit in a federal court. He was not a citizen of Missouri. Case closed, but not for Taney. He insisted that the Supreme Court take the case. And hearing that another justice was writing an opinion that Dred Scott's residence in Illinois and the Minnesota Territory freed him, and knowing that Missouri had once allowed for this, if you were free and then you came back, slavery did not reattach. All right. He decided to write an opinion that would settle the matter once and for all for the entire country. Now remember, Congress was deadlocked over bleeding Kansas. President James Buchanan, old doughface, didn't want to face the issue. So Taney was going to help them out. He was going to help out Congress, and he was going to help out the president. He said that Congress could not violate the Fifth Amendment, and barring slavery from the territories was taking property away from the master without due process. That was not necessary to settle the case. It's dicta. But he didn't stop there. He also opined, based on flawed history and his own racial notions, that people of African ancestry, and the only way to tell that was, for him, color, could never be citizens of the United States. This was manifestly false as history and false, too, on a plain reading of the text of the Constitution. In the North, his dicta was taken as a warning that slavery could come north, despite state laws against it. The Northern response, Abraham Lincoln, giving a talk in Springfield before his debates with Stephen Douglas. And he said, "A house divided against itself cannot stand." About 3 months later, William Seward, who was Lincoln's great rival in the new Republican Party, was giving a campaign speech in Syracuse. And he said, "The slavery issue will bring an irrepressible conflict." So that was the Northern response. The Southern response was hallelujah. The Southern response was that now we have a national law that protects slaves wherever we take them. Wherever we take them. Well, we know what settled the issue. The Civil War settled the issue. The 13th Amendment settled the issue. But the end of slavery and the Civil War did not prevent returning Confederate veterans from establishing a regime of Jim Crow, state-mandated segregation of public facilities. Private facilities were already segregated, including public transportation and education. I don't know if you were here when William James Hoffer stood here and gave it to, that's my son, it's my older son, about Plessy. Plessy was one of those cases, but it was in the middle of a long run of cases. The NAACP, its legal defense fund, won after the separate but equal rule, proving over and over again that separate was never equal, and then finally turned its attention to segregation itself. Now, I don't have to retell for you the story of Brown versus Board of Education. It's part of our national heritage. I believe it stands like the Declaration of Independence, Lincoln's Gettysburg Address, and Roosevelt's Four Freedoms. It speaks hope to fear and justice to indignity. But it ran against precedent. It was as much a legislative as a judicial step and rested on extra-legal as much as legal grounds. It was celebrated simply because its time had come. It reflected the future, one nation, not two, partitioned by race. It led Congress and the presidency by a decade. That it was not fully enforced was a tragedy in part imposed on the court by Chief Justice Warren's desire for unanimity and Justice Felix Frankfurter's concern that a decree that schools should be desegregated forthwith would be met with massive resistance. In fact, the delay enabled massive resistance. Now, it's clear that segregation disfigured our public life. It gave our enemies abroad an effective propaganda tool. It had to end, which brings me to my fourth proposition. The endless rounds of increasingly intrusive state mandates on abortion providers, followed by temporary injunctions against the most severe of them, remind us that the battle out of doors over the issue of abortion is stuck in neutral. Right to choose and right to life are not prone to compromise. In elections for the presidency and Congress, abortion remains divisive. It has become what one observer called a litmus test for nomination and confirmation to the federal bench. It skews the process from one of merit and ability of candidates to one of stance on a particular issue. It stalls appointments, leaving the bench depleted in manpower, and delays the resolution of cases. Most recently, the nation watched as Ohio, North Carolina, Mississippi, and Texas have added new regulations. The Texas regulation is perhaps the most stringent, no abortions after the 20th week. The North Carolina regulation that as soon as a fetal heartbeat could be detected, one presumes by a doctor, that there can be no abortions. That has been stayed by a temporary injunction. When the governor of Mississippi signed his state's law in 2012, he said, if it closes the one clinic, there's one clinic in Jackson, then so be it. Republican Lieutenant Governor Tate Reeves said, we have an opportunity today, the signing of this bill, to end abortion in Mississippi and also to protect women. Another one of those. Ironies. Well, women do vote in Mississippi, I am told. A majority in the House of Representatives would ban abortion altogether after the 20th week. That is the Texas plan. Just how a doctor or a prosecutor could determine when 100 days had passed is not clear. Presumably you'd have to register in some way. No more so than how a woman knows for sure that a missed period means a pregnancy. Each new regulation seems a kind of wink, wink, nod, nod. Sometimes a politician will actually let the veil slip and explain that the real reason for his or her views is to appeal to his or her base. Thus the debate becomes purely political. How do I win this re-election? By ensuring that my base votes for me. Which brings me to my unconclusion. The real I'm sorry, it's the only word I could think of. The real dilemma that we face is not that Roe was right or wrong, that abortion kills a living being, or that abortion is one among the many medical procedures that should be left to a doctor and her patient. That states should determine laws, health and welfare for their citizens, not the federal government, or that people facing life and death decisions should not be left to the vagaries of the state in which they happen to live. The real dilemma we face is how to prevent this debate from so distorting our national priorities and our national politics that we lose sight or cannot address some of the more far-reaching national, international issues, issues that touch all of us, like jobs, immigration, climate change, and global terrorism. One-issue politics serves all of us ill. If we cannot resolve the abortion rights debate, we must agree to move on. After all, to recast Thomas Jefferson's famous first inaugural, where he said, "We are all Federalists, we are all Republicans, we are all pro-choice, we are all pro-life. We value the individual's choice, we value human life and being. Maybe we can come together on that, but we cannot go on as we have. That much is certain." Thank you for inviting me.